Here are the 5 ways to avoid the probate court with your stuff. Hi, my name is Mike Rutkowski, estate planning, asset protection, and elder law attorney, and we're gonna dive into today the ways to keep your assets and stuff out of the probate court. Why would you wanna do that in the first place? Typically, it has to do with time and money, or some personal experience that you've had with the probate court. But in the state of Michigan, the probate court's gonna take anywhere between 9 and 18 months, or longer if people are fighting over things, to distribute those assets, so we don't have access to them. And then the money part of it. Usually it's going to cost anywhere between 3 and 10% of the value of the estate if an estate has to go through probate. So do some quick math. A house worth $100,000, that house alone could cost $3,000 to $10,000 to move it through the probate process. So let's get into it. How can we avoid the probate process? Well, first, naming beneficiaries on accounts is a way to avoid probate. Now, we're not going to get into the strategies today, the why we would do one over the other. We're just going to simply go through the ways that an asset can transfer from one person to another without going through the probate court. So the first one, beneficiary designations. You can do on your 401k or IRA. Retirement accounts can have beneficiary designations. Checking and savings type accounts can have pay on death. There's all kinds of beneficiary designations out there that you can use to make it transfer. The asset will transfer from you to whoever you name as beneficiary after you pass away. So beneficiary designations is number one. The second is a trust. You can use a trust to pass assets from one generation to the next as long as the trust is properly funded, meaning the assets are in the trust. They will avoid the probate process. Often we see in practice that someone might create a trust, but they don't properly fund it. And if you don't properly fund it, you're right back in the probate court. The next option is a ladybird deed. This really only is a tool for real estate, and not every state in the country will recognize ladybird deeds, or also called life estate deeds. It's essentially a way to create a beneficiary designation on real property. So on your home, you can transfer it to a child or whoever you want it to after you pass away. It gives you the right while you're alive to still sell it. You have complete ownership, interest, and rights while you're alive, but that's another way to avoid the probate court on real estate. The next is joint account ownership. So as maybe spouses might both be on a checking account. If one of the spouses pass away, the other one will maintain ownership and control 100% of that account. I've also seen where children's names are added to an account. Now, we're not going to go into today, like I mentioned, of why you might not want to do that, because we highly advise against that, but it is a way that an account will go to the next generation without having to be probated. The final thing is just gift away your assets. You always have the right while you're alive to give away your stuff, your money, your household furnishings, whatever the case may be. Now, there can be tax implications with this. Definitely with all of these strategies, you want to consult a professional on the best way to do it or what makes the most sense for you. But those are the 5 different strategies to avoid the probate court. Again, my name is Mike Rutkowski, estate planning and elder law asset protection attorney. Give our office a call today, check out our website, and schedule a free discovery call.